Okay, so you guys saw my other video, so you know that your exam is being posted on Monday. You'll have a week to take it. Very similar to your quiz, it'll be posted on Blackboard. If you have any questions, please email me at analyrates@gmail.com. Excuse me. I'm just going to dig straight in to our lecture, and please email me if you have, excuse me, if you have any questions. Okay. So last class, we talked about fundamental American liberties. Today, we're talking about the struggle for equal rights. In 2016, we talked about when the majority becomes the minority. This was a time for coming out of the shadows. Trump was showing this America First mentality that maybe worked electorally. The overtly racist alt-right ideology that opposed immigration, multiculturalism, and the classic democratic values really became part of his campaign. Trump's remarks encouraged bigotry. He said the big problem in this country is being politically correct. He ignited and gave hope to a dark side of American politics. His campaign made deliberate appeals to voters' sense of racial and gender grievances. Many felt liberated by his campaign, and folks out of mainstream views have felt that their ideas were finally taken out of darkness. But mainstream America is becoming more diverse, and groups that white nationalists disdained are slowly becoming the majority, even as they themselves become a smaller and smaller percentage of the population, which kind of therein lies the rub. They were vocal supporters of Trump, but they're a small group. A lot of Trump supporters were local males, rural males without college educations who would never think of themselves as racist. Who recognize the white privilege that they were born with only in its absence as they compete for their dwindling share of the American dream, as they were told it was their birthright, and those who believe they are in fact targets of racist behavior. Trump used language that was key to invoke a nostalgia for America long gone. Make America great again. Used again and back, speaking to people who think America isn't as great as it once was. Excuse me, more of a cultural nostalgia. Great for some, but not as great for others. Women, African Americans. Racism has been a permanent thread in American political fabric and might always be, but there are new undeniable facts. Excuse me. Racial landscape is changing. Whites are a diminishing racial group, and people of color are growing in numbers. There are nearly 11 million undocumented workers who live and work in the United States with no easy way to repatriate them. What's at stake when a demographic group that's accustomed to being privileged starts to lose its majority status? What's at stake in civil rights politics in general? When you consider where we started, progress toward equality in the United States can look pretty impressive, like racial equality. Just over 60 years ago, it was illegal for blacks and whites to attend the same schools. They couldn't use the same swimming pools or drink from the same water fountains. This is a distant memory for most of us. Exactly 40 years after Martin Luther King Jr. said he dreamed of a day where a child would be judged by his character and not by the color of his skin, Barack Obama accepted the Democratic Party's nomination for presidency, which he won twice. But there still remains few blacks in national elected office. In 2002, USA Today wrote, if the United States Senate and National Governors Associations were private clubs, their membership rosters would be a scandal. They're virtually lily white. Civil rights, we talked about last class a little bit, are citizenship rights guaranteed to the people primarily in the 13th, 14th, 15th, 19th, and 26th Amendments, and that are protected by the government. Formally granting a civil right doesn't necessarily bring about speedy change in social and economic status. It also includes Native Americans, Hispanics, Asian Americans. All have faced unequal treatment in this legal system, job market, and schools. Women, half the population, have long struggled to gain economic parity with men. Sexual orientation, age, physical abilities, citizenship status, these are also groups that are often denied rights. Intersectionality is the interdependent discrimination and oppression that results when an individual is a member of more than one oppressed minority group. For example, you're black, female, and poor. The United States is haunted by traditions of unequal treatment and intolerance that it cannot entirely shake. As we pay attention to rights of these are haunted by these traditions, it's seen by some white people as diminishing their own rights. When is different treatment okay? Americans expect that laws should treat people equally, but laws by nature must treat some people differently. Laws discriminate between those who abide by society's rules and those who don't. but also can treat criminals differently once they're convicted. In all but 2 states, felons are denied the right to vote for some length of time and sometimes permanently. In fact, I was working for a judge after I graduated from law school. We had a guy who came in front of us and he said, "But Judge, please don't take away my right to vote." If someone is denied a basic right based on characteristics like race or religion or something like that, deciding which of these characteristics may be the basis of unequal treatment is the job of all 3 branches of the government, especially the courts. Can the law treat people differently? There are 3 tiers, classifications of people who are, first is the classification of people who are so rarely constitutional, they're immediately suspect. Suspect classifications require the government to have a compelling state interest for treating people differently. Race is a suspect classification where a discriminatory law must be justified by a compelling state interest. Courts subject it to a heightened standard of review called strict scrutiny. This is a heightened standard of review to access the constitutionality of laws that limit some freedoms or make a suspect classification. The second is classifications that the Supreme Court views as less dangerous to fundamental rights. They fall in this middle tier, quasi-suspect classification. They're subject to an intermediate standard of review, which can evaluate to see if the law requiring different people bears a substantial relationship to an important state interest. An important state interest test is not as hard to meet as a compelling state interest test. For example, laws that treat women differently than men fall into this category. The third is the least scrutinized category for non-suspect, which is subject to the minimum rationality test. This is a standard review that asks whether the government had a rational basis for making a law that treats a given people of a class differently. Laws that discriminate based on age, curfew for younger people, economic level, higher tax rate for those in a certain income bracket, they need not stem from a compelling or an important government interest. The government just must merely have had a rational basis for making the law. This is fairly easy for a legislature to show. All 3 of these groups feel discriminated against, so they all want to be viewed as a suspect class, so they all can be a protected group. The Supreme Court is likely to permit any laws to treat them differently, so gaining this status is crucial to the struggle for equal rights. When do we deny rights? Usually this is explained by creating a narrative focused on the characteristic of a group. A group is maybe not civilized or does not recognize the true God. People are compelled to justify poor treatment by blaming the group that they are treating poorly. People often deny the rights of others because rights are power. To deny a right is to have power over someone and how they will live their lives, to force them to conform to our will. Slaves were compelled to work for a master's profit. Women were denied the right to divorce their husbands. We forcibly removed Native Americans from their lands so those lands could be developed. Denying a right keeps someone submissive and dependent. When someone finds a voice and can effectively demand rights, laws change and they soon can leave subservience behind. People also deny rights to isolate categories of people, maybe recent immigrants who don't speak English. This helps build a group narrative that defines who they are. It helps the communities believe that they, with their cultural values and beliefs, are superior to those who are different. This promotes cohesion and builds loyalty to the people who are like us mentality and intensifies a dislike and hostility to those who are not our kind. This is only a small step away from there to believing that people outside their community don't really deserve the same rights as those superior people within. Disputes arise because we often think equal must mean identical or the same, thus making equality threatening to the American value system, which prizes freedom to be different and unique. We rely on our government to guarantee fair treatment and equal opportunity, which is procedural guarantees, which we've talked about, rather than to manipulate fair and equal outcomes, substantive guarantees. We want the government to treat everyone the same, and we want people to be free to be different. We also don't want the government to treat people differently in order to make them equal at the end. When laws are changed, this is a procedural solution, but substantive action may still be necessary to ensure equal treatment in the future. Narratives of white supremacy and Black inferiority were told to numb the sensibilities of European Americans. This has been almost as dangerous as the history of slavery itself, and has lived on in the American psyche and in politics for much longer than the practice they justified. Racism. is the institutionalized power inequalities in society based on the perception of racial differences. This is not a Southern problem or a Black problem. It is an American problem, and one that we have not yet eradicated from national culture. Would it be a good thing or a bad thing if we treated people all exactly the same? What would it look like, I wonder? In the time before the Civil War, there were almost 4 million slaves in the South and nearly 500,000 free Blacks in the rest of the country. But even if slavery was illegal, Blacks did not enjoy the full rights of citizenship. In the case of Dred Scott versus Stanford in 1857, the Supreme Court ruled that Blacks can't be citizens because the founders had not considered them when the Constitution was written. Abolitionists were a coalition of free Blacks and Northern whites that worked to end slavery prior to the Civil War. They tried to put pressure on to hold statewide votes on Black suffrages, but they lost by large margins. The Emancipation Proclamation. President Lincoln was not simply taking a moral stand with this. He was trying to use economic pressure to keep the country intact. His Emancipation Proclamation didn't free all slaves, only in those states that rebelled against the Union. The 13th Amendment banned slavery, which was passed by Congress in 1865, and it was a huge blow to Southern white power. The South retaliated to ensure their dominance with Black Codes, which is a series of laws designed to restrict the rights of former slaves before the passage of the 14th and 15th Amendment. It essentially sought to keep Blacks in subservient economic and political positions by legally restricting most of their freedoms, voting, property owning, education they'd gained by becoming citizens. Reconstruction, the period following the Civil War during which the federal government took action to rebuild the South. The 14th Amendment was passed in order to make Black codes unconstitutional. The 15th Amendment effectively extended the right to vote to all adult males. Southern life began to change. Blacks voted, some were elected to local offices, but Southern whites responded with violence. The KKK, lynching, arson, assaults, beating. It made it scary to associate. Southerners started setting about the business of stripping Blacks of their newfound political power. Disenfranchising Blacks became easy to accomplish. The 15th Amendment said that the right to vote couldn't be denied on the basis of race, color, or previous condition of servitude, so the Democrats who controlled the South set out to deny it in other ways. Poll taxes. Taxes levied as a qualification for voting. This took away the right to vote for most Blacks who were too poor to pay to vote. Literacy tests. Tests requiring reading or comprehension skills as a qualification for voting. Most Blacks were denied education, so they couldn't read, but if they could, a registrar would administer the test unfairly. Jim Crow laws. These were Southern laws designed to circumvent the 13th, 14th, and 15th Amendments and to deny Blacks rights on basis other than race. Jim Crow was a pejorative expression meaning Negro. Segregation, of course, is the practice and policy of separating races, separate facilities for Blacks and whites for leisure, business, travel, education, etc. Facilities that for whites were newer and cleaner and more comfortable. In the case of Plessy versus Ferguson, the Supreme Court said that they established the principle separate but equal. At the time, folks embraced separate but forgot the equal part of the ruling, thinking the Supreme Court had approved segregated facilities. The NAACP was an interest group founded in 1910 to promote for the civil rights for African Americans. They were able to develop strategies that was finally the undoing of some of these Jim Crow laws. Thurgood Marshall was a young lawyer with the NAACP who decided to launch the attacks in education. Instead of targeting elementary schools, which would have terrified whites, they started with law schools, which would fly under the radar of most. There were no Black law schools. And the Supreme Court knew well these injustices, so this was a masterful strategy. The justices had the shared experience of law school, and it was impossible for them to refute arguments that separate education was unequal. So Brown versus the Board of Education of Topeka, this is a Supreme Court case that rejected the idea that separate could be equal in education. They held that separate by its very definition could never be equal because it was the separation itself that made Black children feel unequal. Segregation in education was inherently unconstitutional. So the civil rights movement came about. Rosa Parks sat on a bus in Alabama and refused to yield her seat to a white passenger, so she was arrested and sent to jail. There was a bus boycott, the refusal to buy goods or services, or as a way to protest policy or political reform. They boycotted the bus system after this. There are two different types of discrimination. De jure discrimination, discrimination by the law, that arises from or is supported by the law. This is what most Blacks in the South faced, especially rural areas where Blacks and whites worked and lived side by side. So but they had to use separate facilities because the law said so. This is de jure discrimination. De facto discrimination, discrimination in fact. This is the discrimination that is not the result of law, but rather of tradition and habit. It's a lot more difficult to eliminate. Segregation in the North was this way because blacks and whites didn't live and work in the same places. It wasn't laws that kept them apart, but past discrimination, traditions, customs, economic status, residential patterns. This was hard to remedy because there are no laws to change at this point. Martin Luther King Jr. became known for his nonviolent approach to political protest, not just for the practices it challenged directly, but for the pressure it brought to bear on the elected officials who had the effect it had on public opinion. JFK at first didn't want to alienate Democrats, but the political pressure of black interest groups forced him to take a more visible stand. He sent federal mediators to Birmingham to negotiate an end to segregation. Excuse me. And then he sent Congress a massive package of civil rights legislation. LBJ ended up making them his top priority because JFK did not see them live to see them become law. The Voting Rights Act of 1965 allowed discriminatory tests disallowed discriminatory tests like literacy tests, and provided for federal examiners to register voters throughout most of the South. The Supreme Court did back this up. The 24th Amendment outlawed poll taxes in federal elections. Black Muslims, led by Malcolm X, Black Panthers, Student Nonviolent Coordinating Committee, they all demanded black power and radical change. They rejected the peaceful attempts that Martin Luther King Jr. had to bring about gradual change. There was something called a busing. They tried to achieve racial balance by transporting students to schools across neighborhood boundaries. Black students would be bused to schools in white neighborhoods and vice versa. Parents who moved to better neighborhoods to send their kids to good schools were unhappy with this. The Supreme Court endorsed busing as a remedy for segregated schools, but ruled later that the busing plans couldn't merge inner city and suburban districts unless they could prove that the lines had been drawn in a discriminating manner. Some early efforts at affirmative action. As the North showed, the absence of legal discrimination does not mean equality. In 1965, Johnson had an executive order that prohibited discrimination in firms for doing business with the government, ordered them to take affirmative action to compensate for past discrimination. Affirmative action, of course, is the policy of creating opportunities for members of certain groups as a substantive remedy for its past discrimination. For example, if a firm had no black employees, it was not enough to have a policy against not hiring them. The firm had to actively recruit and hire blacks. This counted in universities as well. The Supreme Court affirmed this decision, though it took issue occasionally with specific implementations. The end result of affirmative action seems attractive, but the means to get there, treating people differently, seems inherently unfair in the American value system. Do you agree or disagree? So there have been some political gains and losses in blacks in contemporary American politics. Obama, of course, served 2 terms as the president. His election promised to usher in a much more relaxed attitude toward race, but he faced unprecedented obstruction from Congress, and many Americans said he wasn't even born in the United States and was never qualified to be president. One commentator had called Donald Trump's election a white lash to Obama's presidency. Affirmative action today, it cannot be about racism and bigotry, but 2 images of what America ought to be about. One side has this vision of America whose discriminatory past is past and whose job today is to treat all American citizens the same, providing a lower set of standards not fair to anybody. People tend to perform at the level of competition. When the bar is raised, we tend to rise to the occasion. And that's what folks will do in a society that has equal standards for all. But the other side of this is that those who argue that affirmative action programs have made a real difference in equalizing chances in society, though they are meant to be temporary, their work is not yet done. There are other folks who've had their rights denied based on race and ethnicity. Native Americans, obviously the original inhabitants of this continent, and the colonists and their government have always had a difficult relationship. Lingering effects of those tend to be colored today. Article 1, Section 8 of our Constitution says it gives Congress the power to regulate trade with foreign nations among the several states and with the Indian tribes. They are perceived as neither foreign countries nor states. The Supreme Court in 1831 said they were domestic dependent nations. Congress continually denied them many rights promised in their treaties in order to exploit the natural resources that were so abundant in the western lands they had been forced onto, or as they had been forced to sell rights in order to survive. Indian tribes are citizens of tribes as well as citizens of the United States with rights coming from each. And reservations are separate legal entities under the federal government. Since the 1980s, they've parlayed their status as semi-sovereign nations into a foundation for economic prosperity, including if a state allows any gambling at all, the Indian reservations may allow all sorts of gambling, subject only to regulation from the Bureau of Indian Affairs under the Department of Interior. Some Indians see gambling as their economic salvation, and others see it as spiritually ruinous. Hispanic Americans, that's another diverse group with a history of discrimination. They face peculiar challenges of their own in trying to fight discrimination and raise their standing. There's a language barrier, which is a political reaction to immigration, and they're the largest minority group in the United States. There have been things called the English-only movement, efforts to make English the only official language of the United States. This has appeared on ballots and official documents. It's clearly about more than the language. It's about cultural and national identity, a struggle to lay claim to the voice of America. Asian Americans, identifiable by their appearance, it makes them harder for them to assimilate into European American population. Of course, the exclusionary laws of 1882 and 1925, but the anti-Asian sentiment was at the highest during World War II when Japanese Americans were rounded up, forced to abandon or sell property, and put in detention camps for national security reasons, even though 2/3 of them were American citizens. There is an unusual feature of Asian Americans is their overall academic success and economic prosperity. They're forced out of wage labor in the West by the 1880s, and resentful of their white owners. They had to become entrepreneurial, and many owned their own businesses and restaurants. It's interesting. You think voter turnout should be high among Asian Americans because it usually corresponds with education and income, but Asian American turnout is typically the lowest in the nation. They tend to register as independents, but they simply may not vote because no one asked them to. Then there are rights denied on the basis of gender. Women's struggle for equal rights has perhaps been the most peculiar because women were not outside the system in the same way that racial and ethnic groups have been. Women's work was in the home, and white women were to be too good, too pure, too chaste to deal with the sordid world outside. Women weren't exactly slaves, but they weren't much different. When a woman married, she merged her legal identity with her husband's. She could no longer be a party to a contract, bring a lawsuit, own or inherit property, earn wages for service, gain custody of her children in case of divorce, initiate divorce from an abusive husband. If her husband was not a U.S. citizen, she lost her citizenship. Neither married nor unmarried women could vote. Unmarried women didn't have a lot of opportunities. They worked in domestic service and later in the textile industry. Most married women did not work outside the home. The birth of the women's right movement came about in 1848 in Seneca Falls, New York. Women targeted states that were sympathetic toward them and gained political clout, so they started being heard on a national level. If women gained equal rights, the entire way of life would be over, which was probably true. But most women lacked the money and political contracts and experience to get involved in politics. Politically active women were ostracized and accused of being unfeminine, making political involvement too costly to many. The 19th Amendment came about and gave the women the right to vote, but it didn't ensure constitutional protections against discrimination. The Equal Rights Amendment was a constitutional amendment passed by Congress but never ratified that would have banned discrimination on the basis of power. There's talk about all the time ratifying the Equal Rights Amendment. The Supreme Court began striking down laws that treated women differently by using equal protection from the 14th Amendment, taking it a sign that ERA, Equal Rights Amendment, was unnecessary. Gender discrimination today, some laws that still do treat women and men differently have been upheld by the Supreme Court. For example, statutory rape laws requiring that only men be drafted. Obama signed the Lilly Ledbetter Act in 2009, extending the time frame for workers to sue if the wage discrimination against themselves revealed itself over time. Paycheck Fairness Act prohibits discrimination and retaliation against workers who bring discrimination claims. Remains controversial. Sexual harassment, of course, is unwelcome sexual speech or behavior that creates a hostile work environment. Oftentimes, workplaces are unpleasant, offensive, and usually stressful, women often face retribution for calling attention to sexual advances. There was a high rise in the number of cases of discrimination reported by pregnant women. Roughly half say their bosses reacted negatively to their pregnancy. The Supreme Court ruled in 2015 that if a business was not intentionally discriminating against a pregnant woman, it couldn't impose the burdens on her in violation of the Pregnancy Discrimination Act without sufficient justification. Obviously, women have entered politics. In 2016, the first woman presidential candidate came about with Hillary Clinton, and now we have our first woman vice president. There are rights denied on other bases. Sexual orientation. Until 2011, gays couldn't serve openly in the military. Congress passed in 1996 the Defense of Marriage Act, asserting that states need not recognize gay marriages performed in other states, which the Supreme Court struck down in 2013. The Supreme Court, some other ways that rights have been violated. Age. Younger people can't vote, but older people defend their interests very effectively. But voter participation rates rise with age, and older Americans are typically well organized politically. Disability. In 1990, the Americans with Disabilities Act modeled on the civil rights legislation that empowers racial and gender groups. This protects the rights of the disabled, guaranteeing protection from biased employers. What about citizens? Should non-citizens have the same rights as citizens? The Constitution gives most of them the same rights except for the right to vote. Can you think of any other groups that face discrimination? The pluralist model of democracy best describes the actions that citizens have taken in order to gain the government's protection of their civil rights, and emphasizes the ways that citizens can increase their power by organizing into groups. All right, guys, thanks for hanging with me today. Let me know if you have any questions about the exam, and we will come back the week after your exam. Let's see, let me pull up my syllabus. So you'll have your exam the week of February 7th. You won't have any lectures that week, and then we'll be back the week of February 14th with a lecture on Congress. Thanks for hanging with me. Email me with any questions. Bye.